Welcome to another Grung Spotlight on Silence episode. The Armenian Center for Political Rights, the ACPR, and the Helsinki Committee of Armenia released a report last week on the police brutality against protesters on June 12th, earlier this month. Also, the Parliamentary Assembly of the Council of Europe, PACE, released a report about Armenia's honoring its commitments and obligations to Europe. So those reports are our topics today, and we have with us Rafael Ishkhanyan to discuss those. Hello, Rafael. Welcome back.
Hello, Asbed. Glad to be back with you.
Glad to have you.
Talk to you, Rafael. So, to begin, your organization released the report on June 12, on the activities of June 12. On that day, the Pashinyan regime clearly showed that they're ready and willing to use disproportionate force to suppress protesters. And up to 100 people sought medical attention after the police lobbed dozens of stun grenades at the protesters, and many of them were severely injured. And among the injured were several journalists, including Abraham Gasparyan from ABC Media. RSF, Reporters Without Borders, criticized the Armenian police for deliberately targeting journalists. Rafael, you were there on the scene that day, monitoring the protests. Can you tell us what happened? How everything started? I know some of this is in your report, but tell us, in your own words.
Okay. So for some context, if people are following the protests of this movement led by Archbishop Chalabyan, I think that and if you compare it to the recent, let's say, movements of opposition that happened last year, sure, there can be drawn many similarities. Mostly the use of the tactics, the protesting tactics, the civil disobedience techniques, and overall organization. And I think this also has its positive and negative, aspects to that. By that I mean one of the main techniques what the organizers are calling the non-violent civil disobedience, and which is of course a type of protest, which is of course inherent part of the peaceful assemblies. There's this notion that the civic disobedience, if it's peaceful, and later we cover what peaceful is, because there's a lot of talks about that, that there may be breaches of some legal regulations if you are exercising the civic disobedience. The thing that the legal, let's say, consensus is that as long as it's peaceful, that is, as long as there is no actual violence or the risk of imminent violence by the large part of the protesters or by the organizers, which, by the way, have to be proved by the counterpart, by the police in any case. So they may breach some legal rules, and they are doing that willingly. And those who exercise civic disobedience, they are agreeing to, let's say, to take the responsibility, which may be, let's say, I don't know, fines if there are some minor offenses, etc. But this is still included in the right to peaceful assembly. It sounds counterintuitive, but the thing is that whatever rules those exercising disobedience are breaking, those are, let's say, minor traffic regulations, or let's say some regulations concerning the conduct of the assembly, for which later there may be this minor offense proceedings, like administrative proceedings. And that's the way how the police is supposed to counter civic disobedience. So when we're talking about that, it's not that whoever wants and for how long they want, they can block whatever street they want. They can do that, of course, but then, of course, there may be consequences, and there are legal stipulations for that. So the police can, I don't know, go to the court and file a suit against the organizers, let's say, and then if they prove it that it violated some rules, so the organizers may be subjected to a fine or some administrative penalties. So why I'm putting this first time, because what the police is doing is exactly the opposite, what they are not supposed to in these situations. So the peacefulness of any assembly, this is something that has to be presumed. So it's peaceful. You treat it as a peaceful as long as there are no actual reasonable and very strict evidence of the contrary. And the contrary is not some isolated acts even by some number of the protesters which are engaging in violence being physical violence in this case. But there should be there's some scale to that. That means you can't say the protest was not peaceful because there were violent protesters. You can only say that if there was predominant behavior or the organizers clearly had this intent of violence. And by violence, of course, that's the physical violence. The brawl with the stampede with the police, this is not a violence per se, because it also may constitute a part of civic disobedience as long as they are trying to push to the lines. And why I'm saying this, because in Armenia, this has become a norm. This has become a, let's say, culture of protests, and it has been exercised for many years, even in 2018. And if you look into the report, we draw some comparisons with one of the protests in 2018, which was led by Pashinyan himself, and the one in June 12, led by Archbishop. And the similarities of the disobedience to the police orders, that means the blocking of some certain pathways, certain streets, and not allowing the protesters to go, and the organizers are nevertheless trying to break their way through the police lines. Of course, trying to do that with the armed police, with the shields, and of course, supposedly they should have some proper training. In 2018, we've seen, let's say, compared to what's been here, much more professional behavior from the police side. So when Pashinyan supporters tried to break through, and actually the reasoning was the same, that he was an MP at the moment, and he was telling that he and the other MPs have to go to the parliament, their workplace, and they are inviting the other protesters with them. So clearly the same situation that we had in June 12. So basically the police tried to negotiate, and quite politely, if you look there are the videos when Osipyan is trying to negotiate with Pashinyan to basically make him to change his mind. But then he's going through the lines, he's breaking the lines, and then the huge mass of protesters are breaking through the lines. Of course, some of them were using the same, let's say, techniques as when others are calling it a violence, that means throwing some objects on the police officers, including taking their shields and batons. And then police is regrouping and then putting the barbed fence. And only after that, they are using the stun grenades. And I think there were 4 or 6 of that. So that's what's happened in 2018. And then we draw the similarities with the current one. What happened basically in June 12 was it started in similar manner, and the organizers and the MPs, opposition MPs, tried to break through the police line. The police did not let them, and then some protesters broke through the gates to the Lovers Park, and then when the commentaries, let's say, diverge on what happened at this moment, because this brought to this clash, and not the clash, but the use of the stun grenades. When we were at place and were monitoring, of course, you could have the idea, if you're watching from one perspective of what's happening there, you see protesters climbing to the fence and the fence is falling off. You have the perception that there's something going maybe to erupt into violence. But then there are dozens of video footages what happened inside the park at the moment. And the only violence you can observe there is basically the violence that the Red Berets were using against the protesters. So the violence went to the moment that, and this is also documented in video, so we have in a report, that high-ranking police officials have to intervene, and they have to drag the Berets back because they were engaging in, let's say, very unprofessional behavior with protesters. So after that, when the police left the park, they closed the gate, and there's everything. What I'm saying, this is absolutely in details recorded in from many angles, many videos. There was this, let's call it a relative peace, when just everyone was standing as they were. There were journalists in a row, there were protesters in the other side of the fence, and the police on the other one. So when we examined those videos, we saw that immediately after that, the police chief and the deputy, I think the commander of the police troops, so they had some consultations, what it seems like, under the camera. And then they call some other policemen who bring the grenades and just start to throw indiscriminately on the people standing in the park. So that's what happened, and this is again well documented, and it can be seen in all the references in the report, so everyone can check for themselves. So why I'm saying this? Because there was debate. Well, the stun grenades were used with violation of the procedural regulations, or there were no need to use them at all. So of course there were no need to use them. There was not a situation of a violent protest. The protest was absolutely peaceful at the moment, at least. However you try to construe what's happened there, it was absolutely peaceful at the moment when stun grenades were used. And again, of course, after taking that into account, and then we can also discuss how it was used, because even if you are using it illegally, then at least there are some other procedural laws that there's norms how you have to use them if there are people standing there. So those grenades are not meant to using against individuals, against people. They are basically for creating the shock effect, or let's say storming a building if there are some terrorists with hostages. This is a use case scenario for this type of grenades, but they were used just as a punishment for the protesters.
Rafael, I watched that very first video as well. And as you say, it can clearly be seen that the police chief, Armen Ashotyan, is talking to Hovik Babayan, the commander of the police forces, and they're pointing in the general direction. The guy with the grenade comes, he lobs the first grenade, and I believe it's been documented that that very first grenade landed immediately in the area of the reporters, and that's when the reporters got injured. So it was not clear to me what the purpose of that was. I mean, in general, yes, you're not supposed to throw it at people, but why even throw it at the reporters? It just seems like either it was completely indiscriminate or even targeted at the reporters. What can you say about that?
I mean, we can't exclude that it was they may target journalists because you want to some event which is like it's inherently illegal. You don't want it to be documented. There's the rationale behind that. So, but to my understanding, when I watched this video, the first police officer who threw the grenade and the distance of him from the gate and from the protesters was the way that I think that he couldn't even see the exact spot when the grenade is going to land, but he clearly knew that there were people around it. So we can say that for sure the police officer knew that he was violating the procedure how to use that exact type of Zarya grenade, because he threw it on people. And to take into account the distance and the rows of other policemen in front of him, I think he didn't even think about who's going to be the victim. Well, the journalists were in one of the first rows because, well, the journalists have to be there. They have to document what's happening, and whatever is happening is mostly in the first rows. But then we have it. So back to the comparison. In 2018, after the use of grenades, of course, the biggest reason was that the change of power happened, and Nikol Pashinyan replaced former president and then Prime Minister Sargsyan. And when the agenda was on his side, and the police deputy chief, Levon Yanosyan, was convicted for misuse of those grenades, for abuse of power, if I'm not mistaken. And there was specifically for using those grenades with violation of law and regulations. So the funny part is that this conviction came just 9 days prior to the June 12th protest we are discussing now. So when we, in this regard, when we were saying that one of the reasons of police brutality during the protest is the impunity, because there were no police officers had criminally liable for their actions. Now we had only one example, of course, highly politicized because it happened during the protest that brought to the change of government. But then the criminal conviction, it has to have deterrent effect. That's the idea of the philosophy of the criminal law. But we have the exact opposite. That just 9 days later, the same conduct, much worse, and with much more disregard to any safety and anything, was actually done. So it manifests the exact opposite by what the deterrence should have been. So the conclusion can be drawn just one. If Yaranosian was convicted because he threw grenades against Pashinyan, Aram Hovhannisyan is not convicted, is not even charged because he threw for Pashinyan. Let's put it in this way, for the government. So,
right. I guess it depends on who you're lobbing these grenades against for the charges to apply.
Up to 30 grenades were used, and that has been unprecedented since at least 2018. What are the regulations and policies around the use of stun grenades, and in what cases can they explicitly use these methods, and how exactly?
Yeah, there are several regulations. There are regulations in the law on police, and which enumerates these so-called special measures, which range from the basic police baton to the stun grenades and the water cannon and the barbed fence and the others. And there are regulations on how to use them if you are about to use them. And there are also the overall guidelines for the police on the proportionality and this sort of decreasing necessity or increasing necessity of which type of measures you should use in which cases. So the stun grenades, to my opinion, they are absolutely incompatible with policing peaceful assemblies. And again, I am saying peaceful because the limited number of protesters which even use physical violence, throwing some objects. I'm not talking about empty plastic bottles. This cannot be considered violence. This is a political act because it cannot absolutely no way hurt a policeman wearing helmet and a shield. But if there were cases that let's say that the protesters threw some other objects or I don't know, contacted in a different violent contact with the police, still these isolated events, and if you still have from the other hand, you have the organizers trying to all the time, trying to ease them, trying to separate them, trying to isolate them, unsuccessfully in some cases, but the protest was peaceful. So in this case, the stun grenades are absolutely incompatible in no way. So we're not even talking. We don't have to talk about when they may have been used. They cannot be used in any scenario if there are not absolute riots, because I know. I mean, if someone wants to see riots, well, I think two days ago, that one of the protests that turned violent in Kenya, in capital of Kenya, I saw the footage, I think from CNN. They were showing the street where the stores were looted. There were some cars set ablaze. This is, well, this episode. This is what is the violent protest. This is what the riot is. This may be the use case of stun grenades, or maybe even other, I don't know, more strict measures. Actually, I think the Kenyan police used live ammunition there. But what we had, that the stampede with police and throwing some objects, mostly plastic bottles, it never can substantiate the use of such tool which can be lethal, because we saw someone losing fingers when it exploded in his hand. And imagine what happened if it exploded near someone's head, because there were people lying down when the grenades were still being thrown on them. I think, and this part, I think I'd like to mention one more thing, that the organizers were talking too much about the provocateurs during the assemblies. So this is a very, let's say, very, very hard to prove, because to the organizers of protests, everyone who doesn't comply would be a provocateur, and let's say for the other part, for the police, there would be just an excuse that the organizers use. But in this case, we had at least one documented case of that. So I think on May 13, during one of the assemblies near the church, when the movement were doing their sort of wrap-up meetings after the day, there was this incident that some person attacked with a knife a protester, and actually I think that he received some injuries with the knife. So I was there at the moment, and when I saw some people started screaming, and a guy started to run, and the police, of course, overwhelmed him, and then they arrested him. So later, the investigative committee issued a statement that a person has been arrested as a protester. So they were actually representing him as one of the protesters. So they said between two protesters, a violence happened and one used a knife. So this is a clear documented case of what the provocation is. So this person was, according to the investigative committee, was a 4-time convict, including for deserteering. And they're putting him in their statement as one of the protesters. So of course, this doesn't sound logical at all. What I'm saying this is that with this case in hand, I think it gives more credibility to the presumptions that there have been provocators involved during the protests, and they may conduct some inappropriate behavior, which may be violent, because using a knife in a protest it's a classical example of violence.
Do we know any police officers that were charged with any crimes from the June 12 incident?
No. Disciplinary proceedings, and that's all we get. That's all we get for a long time.
And how many disciplinary proceedings have we gotten so far?
I didn't follow the recent ones. I think there were very few, actually. I don't remember the exact number, but there was less than 10. There was, I think, maybe 2 or 4.
Actually, I think so. I'd have to go back to the articles that we have posted and read. If I recall, there was an article that said that no police were going to be charged with anything regarding June 12th. But don't quote me on that because I'm not 100% sure.
Well, I am shocked, I tell you, that no one is prosecuted. Of course, I say that with sarcasm. Let's move on. We have a few other topics, and we may come back to this incident. So with this June 12th protest in the recent memory, like several weeks ago, as in the Parliamentary Assembly of Council of Europe, PASE, issues a report on Armenia's honoring of its obligations and commitments. And the first paragraph of the report, or the first sentence, is the Parliamentary Assembly commends Armenia for its continuous commitment to democratic development in spite of the considerable security challenges it's facing. And that is basically the entire theme. When you hear one of the co-rapporteurs talk about it, they say, well, Armenia has been through so much, the war, the 100,000 refugees from Artsakh, the difficult peace negotiations. So all these challenges are being presented. And within that context says, given all these challenges, Armenia is doing a great job. And any issues that were happening in this time frame were classified as internal hiccups. And the other co-rapporteur, Boriana Aberg, I hope I'm pronouncing that correctly, also was all glowing in terms of praise, and said the only concern she could name was that the political climate is polarized. Now, I have to also say, and we'll cover this later, because the report did cite your organization, the Armenian Center for Political Rights. They actually quoted and used the information from you, so congratulations on that. And we'll talk about that in the context of the freedom of assembly. But what is your overall assessment of this report?
Well, I think we have to keep in mind, first of all, that Council of Europe, it's a political organization. Of course, the human rights dimension is a huge part of it, and was also the idea back when it was being established, and the European Court of Human Rights, which of course contributed a lot to the development of the human rights, let's say, from the legal perspective. But still, that the council, what's the composition of the pace of the ministers' committee? They are ministers, they are parliamentarians, so they are politicians, and the organization itself is political. So, of course, the report. Well, I mean, I'll look from the perspective of human rights. It does address some of the important issues, and actually, if you even focus on those, it becomes quite hard to swallow the overall conclusion drawn from there. Because to me, when I was reading the report, again, I may have some biases, but rationally, it was very difficult to come to this conclusion that the reforms are going in the great direction. They did a great effort, and disregarding some some issues that happened there. But those issues, and actually the ones that they noted there, were quite serious ones. I think we can. I would talk about some, let's say, key takeaways from the report, which actually did really interest and surprise me, to say, in a good way. And one was that when they were touching upon the judicial reform, of course, many praises there, because again, they are also the partners, and again, this is political in many ways. But one of the biggest issues that we were being vocal for a long time, the influence, the political influence on the judiciary through including the head of the Supreme Judicial Council, Armen Ashotyan, who was just right before appointment member of the Civil Contract Party and the acting Minister of Justice. To my surprise, let's not say surprise, because there was also something that Venice Commission said, but there was also reiterated that the suggestion is not to appoint acting politicians to these high, let's say, important public offices.
And just to remind our listeners, Armen Ashotyan, prior to his appointment as the head of the Supreme Judicial Council, was the Minister of Justice in Armenia and a member of the Civil Contract Party. So, in essence, a politician. They said, the General Assembly of Judges should be reformed, and the Supreme Judicial Council. The only thing they found wrong with it is that there are political appointments in this council.
Yeah, exactly. That's the thing. I mean, we're talking about the judicial so-called reforms. I was saying, so the issue we see that is that the most important office is held by someone who just before the appointment was the minister holding a minister's office and was member of the ruling party, which has absolute say in everything, in parliament, in appointment of any public offices. And I think it's also important because of the character of this person, because before that, when he was an acting minister, there was this famous incident when journalists asked him why you are having Nicole Pashinyan's picture hanging in your cabinet, because he had. And what he said, I think maybe people can find similar formulations in this, maybe even the comedies of some totalitarian states. He was saying that because he's the head of state and head of for all of us, and when I look at him, at his picture, I remember that he wants us to be just, wants us to be brave, and something similar. So that was more or less what he literally said while he was holding the minister's office. So when you're talking about the qualities of an office of this importance, which basically has the most say in how the judiciary will be formed, I think to the end of last year, when they were talking about the results, they said that 80% of current judges, incumbent judges, are appointed after 2018. So basically, this is a confession that a person whose appointment is criticized even from the Council of Europe because of his political role and the political nature of his appointment is proudly saying that the reform is that 80% of judges are the ones that were appointed during one-party rule. Well, one-party rule was always, again, but then many of those who support this were critical before, but for some reason now it works for them.
Yeah, and let me also cite another report from the 2023 Freedom House Armenia report, which I'm quoting: "The judiciary lacks independence and is one of the least trusted public institutions in the country." So while I recognize that the PACE report did, mention a few things, it seems like, out of necessity, the overall picture they paint is that Armenia has gone through reforms of judicial independence. But here's, clear black and white report from Freedom House saying the judiciary lacks independence. Of course, yeah. We don't need Freedom House to tell us. Sure. Like one of the civil contract parliamentarians said, it's not Freedom House who should tell us that there is democracy in Armenia or not. We see it with our own eyes. And I think that, if you're anyone but in a select group of, feeders from the public budget, I would say, in the Armenian government, you will see things more clearly, that there is indeed lack of judicial independence. And this, despite all of our criticism with Freedom House, I think most of the public would agree, as many polls, one after another, state. But now let's move to the peaceful assembly section of the report. Hey folks, hope you don't mind the quick interruption, but we'd like to issue a correction which we caught during editing of this podcast. In the discussion that you're going to hear next, we're talking about incentivized participation in protests. The PACE report mentioned the law quoting Article 136. Unfortunately, that's incorrect. We hope this didn't go out as the final version that was adopted as part of the resolution, but the actual article should be either Article 163 if you're referring to the old criminal code that was active before July 1st, 2022, or Article 236, which is, and the new code that went into effect, as I said, after July 1st, 2022. And in no case is it Article 136. So we apologize for that mistake. Unfortunately, during our discussion, we also used Article 136 without double checking, but the real article number is Article 236 of the new criminal code of the Republic of Armenia. The PAC report starts with, in the paragraph 101, says, respect for the right to protest and response of law enforcement to protests has caused concerns. They proceed to mention Article 136 of the Armenian Criminal Code, which criminalized incentivized participation in rallies. And this is the same article under which Avetik Chalabyan was tried and found guilty, and his case is under appeal. And this is the same article under which several other people have been charged, including Gerasim Vartanyan, a member of the ARF, recently. The PAC report refers to Avetik Chalabyan's case and specifically refers to your work on this issue. So what are your thoughts on Article 136 in general? If you can summarize it for our listeners in a more accurate way than I did, what is incentivized participation? And is it in line with European standards or isn't it?
Well, the European standards are these guidelines on peaceful assemblies. And these guidelines, the one that we have now is the third edition, and it's co-authored by Venice Commission, that means Council of Europe, and OSCE, ODIHR. So it's a very comprehensive document. And by saying guidelines, it's not only, let's say, a soft law sort of compilation, but it's based on both the ECHR and other arbitration, the judicial practice. It's based on the best practice of its member states. Whatever is written there, there is a reference and there's the base in actual legal documents. So when it's called guidelines, it's basically the crystallization, let's say, of the best practices and the current international standards. And this is a great piece of document, and it addresses mostly anything that can be ever related to the assemblies. So the Council of Europe, as I said, and the Venice Commission is one of the authors of these guidelines. And the guidelines address this issue of so-called incentivized participation. That is, when you give some, let's say, sum of money or some other goods to a person, let's say, for his or her participation in a protest.
I'm sorry, does it have to be proven that it's given so that they can participate and, in other words, for instance, earn money, or maybe it's to cover their expenses, such as food and gasoline?
So the thing is that it doesn't address that in that details, because what I think is that because there's just no need for that. So there's this approach. Those incentivized participation, it should not be regulated. Regulated, that means in other way, positively, negatively. So, and absolutely should not be criminalized. The only example, the only exception is if the incentivization is used as a vote bribe. So that means if it's done in the context of a pre-electoral campaign, and even though it only says if it passes the threshold of the proportional financing standards that whatever country has. Let's say you have this amount of money which is allowed to spend for your pre-electoral campaign. You can use that to bring, let's say, paid protesters. Actually, there are countries which have organizations which are providing paid protesters. So it should not be used to circumvent the threshold of financing. So it's a very niche case scenario. And actually, when this article came in force in Armenia, we had one credible situation when it should have been invoked, at least for an investigation, which happened last year during Yerevan municipality elections. And by no other but the civil contract party. The Transparency International and others wrote about that. There have been evidence that they were hiring protesters, or let's say assembly participants. It was not a protest, it was a pre-electoral march to publicize their party. So in that case, of course, we didn't have any criminal case. So back to the article.
Before you go on, let me make a quick comment for the benefit of our listeners that we've included links to all of these reports in our show notes. And what you are referring to at the moment is actually paragraph 102, I believe, in the PACE report, just for reference.
Yeah. And if you're watching this on YouTube, we will also include links by including a QR code that you can scan and be taken to the article in question. And I did read the report as well, and you're right. The report says that the exception is for influencing elections, but I think they were trying to say that that was not the case in Armenia. So one of the questions we were going to ask is the government applying Article 136 proportionately or appropriately? And I think that your answer is maybe
absolutely not. So. Maybe for some context, because we're talking about articles, this incentivization, whatever. Maybe there's needs for some clarification. So this article 136, it's a relatively new one, and it actually covers several crimes, some of which are indeed have to be criminalized. So those are the obstruction to take part in assemblies, which is criminalized, and that's, of course, in line with every standard we can think of. The acts of compelling someone to participate, that means using force or using blackmailing or whatever, something against their will, and those are criminal. And then the third act, which is criminalized, is if you are incentivizing someone materially. Well, with this one, again, I mean, there's no need to go through if it's good or bad having paid protesters. The thing is that the guidelines explicitly say it should not be regulated, which means it should not be criminalized. So why is this important? Because the government, when they had the drafts of this law, they sent it to the Venice Commission and OSCE ODIHR for an opinion. So if you are not going to respect the guidelines, and if it is nothing for you, why are you even doing that? Why are you even sending it for an opinion? That means you are you are respecting this as a commitment. You are respecting it as an international standard, and you want this commission to verify if you drafted everything correctly. Yes. So I think we covered it before that there was the reason that the commission did not address this was the very bad English translation, which lost the idea. The idea was lost that these types of acts of incentivization were without compelling. So the text was written the way that someone reading it may understand that it still has some element of compelling and forcing someone to participate with also the use of some money. But that was not the case. It doesn't refer to any act of compelling. It's just incentivizing financially. So again, and this is of course this is great that the report acknowledged, and of course they also called to the government to resubmit it to the Venice Commission and eventually I think to OSCE ODIHR for another opinion for that, because applying to the Commission is possible only if you are the government, or but not at least not for the civil society. We cannot do that. And let's see what happens. Let's see if they do. I don't think they will, to be honest, because the use case, the history of this use of this article has been proven, let's say, quite beneficiary for the ruling party. Why? Because it also stigmatizes people who've been at least charged with that. Whatever we say about it in the legal sense, I understand that for many people, when they hear, they paid for protesters, this is actually stigmatizing these people, not in a wrong way, you may think, because people won't perceive it, that if the protest was organized by some financial means, the protest is not genuine. So the protesters, whatever they're voicing, is not compelling. But that's the exact reason why the people would not choose to do that, because this lowers the credibility of the protest. And this is actually, let's say, the sanction for involving pied protesters. But it happens by itself. There's absolutely no need to regulate that and even criminalize that. But again, just throw everything away. The government applied for the opinion of Venice Commission and OSCE ODIHR. They have the opinion on that. That's written in the guidelines. If you were not about to obey that, so why even ask for their opinion in the first place? That's what I would ask.
Another shameful paragraph, in my opinion, is right on the first page of the report, paragraph number 4, talking about the clashes that occurred in September 2023. So you have to remember, Artsakh was being depopulated. A lot of people were angry. And I'm quoting that paragraph. The Assembly expresses its relief that clashes with the police forces during these events brought no casualties, in sharp contrast with the 10 deaths that had occurred in March 2008. So we're talking about the March 1st incident. Why was it necessary to bring this parallel with March 1st? Is this a fair comparison?
To me, it's absolutely not. I think it's actually, to me, it's quite inappropriate, this comparison. Because if you think about that, well, in any situation, you can refer to something, let's say, some other horrible example, and then justify whatever. So every country has some examples that it can bring forth every time, and this can be used as a justification for if something been done, in a less strict way or in a more humane way. But the March 1 events are also different than context. The post-election protests, which were part of the elections all the time. And here in 2021, we didn't have that. We didn't have those protests actually starting from 2017 after the parliamentary elections. So from that moment on, we can mark the change of the, let's say, culture some way, because everyone actually accepted the results that moment. It's inappropriate because the countries like Armenia, with their, the very limited resources of doing basically whatever you want in a very violent manner, sometimes you have to, comply, at least make the illusion of complying with some, some standards, better standards. And in 2008 and now, at least differences you can cite, starting from that everyone has a phone in their pocket and can document absolutely what's happening there in a very in a high quality videos and other. So this two situations, basically, to me, I think they are not comparable, because it couldn't have happened the same way here now. So the many variables which are different, but why it was used there again? I mean, we talked about that. The Council of Europe is a political entity, and of course, it sounds like as comforting the Armenian government for some reason, and there may be many reasons for that, of course. But yeah, we have what we have politics in basically everywhere, even if it's about a report on reforms or human rights.
In your experience of writing such reports, are the co-rapporteurs in this case basically sitting down and writing these things, or are they borrowing paragraphs from, let's say, trusted sources or people who are contributing to the source? Because to me, when I read this paragraph, it just basically stuck out like nothing else, and it's essentially a most basic Pashinyan propaganda piece.
In the report, the authors are citing some meetings or debates with whoever that they met during the drafting the report, and at that part, I think at that paragraph, at least it perceives that this is the idea of the authors themselves. At this moment, there's no explicit reference to anything that. And again, I mean, let's just forget the March 1 case of this political manner because it's very politicized case. But why are you bringing?
It just makes no sense. It makes no sense.
It makes the opposite sense, because if you are bringing it as a horrible example of something that may happen, yeah, there are many other even more horrible things that can happen, but that basically reads as a justification. So as long as you didn't cross this threshold, that's okay. That's not what they are saying, I know, but that's how you perceive it. It's in sharp contrast with 10 deaths, there were 0 deaths. If there were 3 or 9.
Perhaps 2008 was more violent because certain leaders of that movement in 2008 were saying that their soul was jubilant because the protesters stole shields and clubs from the police. And the organizer in 2008, called on his followers to pick up stones and sticks and anything else, to, quote, defend themselves. I don't think Belgrade Sirpazan had used that kind of language. And the person who organized 2008, one of the organizers, was Nikol Pashinyan. So we are going to soon talk about 2 cases of political imprisonment and persecution. We're going to talk about Armen Ashotyan and Avetik Chalabyan. Before doing that, however, I think it's really important to talk about the annual Council of Europe report on penal statistics. And if you read the government propaganda or what was published in Armen press, you will see that the imprisonment rate in Armenia is something like 23% or something like that. It's very small, when you compare it to other European countries. However, what they don't mention is pretrial detention, which I think is really important. And Armenia essentially is the number 2 position in terms of the highest rate of pretrial detention in the Council of Europe. And it's second only to Albania. Anything you can say about this phenomenon?
There was this types of criminal sanctions, which also the Soviet heritage. There was this imprisonment when you are being kept with inmates in a prison facility, and there was another type of, I'm talking about a punishment, that means after the court verdict of the detention in a detention facility. So the detention as a punishment was always shorter than the imprisonment in a regular prison facility. Why? Because the circumstances how it being held there, where as the legal scholars were putting that, the reason was the aim was to shock the perpetrator. So the duration of the detention was shorter, but the circumstances which were much more stricter, and that they have the aim. The idea was to put a, let's say, cold shower on the perpetrator to later deter him or her from doing anything else against the law. And the prison sentence was for the reason to isolate someone from the community. So the idea of the pretrial detention, of course, it has to serve different purposes. That means that there are limited purposes for that. If they can obstruct the investigation, if they can hide, etc. But the manner how it's used in countries like Armenia, this is basically a punishment of detention without court verdict or before the court verdict. So you mentioned right, because many people are being put in the detention for, let's say, 2 months or even less, maybe more, and then they let out, and then new ones are being brought, and then they are being let out. So basically, if you look from this philosophy, this legal philosophy, they're applying this shock therapy, this shock punishment on people without having them actually being convicted by the court. So you can say also by violating the presumption of innocence. And this is a very easy operatable tool, because every time the police or the investigative committee, the prosecutor can say, well, we have evidence that this person was going to obstruct the investigation, they're going to hide. And then, this sometimes it passes through because, they have to prove it, but the overall public perceives that, well, yeah, maybe there was some reason to that. Maybe then in the end, when the court deliberates, we can see if it was right or wrong. Maybe they'll be compensated for that. But the punishment is already done. It already had its effect. And that's the reason with that's the to me, I mean, that's the whole story with the pretrial detentions here. Maybe it's necessary to talk about specific cases to illustrate that. And yeah, you mentioned Ashotyan's case because I think it's quite relevant at this moment because a year passed, and maybe several days. He was I think he was arrested in put under detention in June 16th last year. So it's already a year passed through, and his case was quite well publicized in terms of is a classic example of a political prisoner. You can talk about that from many different perspectives. As if you look into his case, when he's being basically charged with money laundering or abuse of power charges for some actions which did not have effect on him in terms of gaining any money. There was a story about compelling. This was what the charge is: compelling the medical university to purchase some real estate, which to this moment belongs to the medical university. So, what is let's say the crime in that? Maybe there been, of course, some abuse of some, let's say, I want to say it a legal way, but maybe there were some irregularities to that. Maybe, but please show me any minister in any country which did not engage in such kind of activity. It's absurd. You're going to put into detention everyone. So my point of view to Ashotyan's case is from the let's say political perspective. So we're talking about someone who is the vice president of one of the largest opposition parties in a country. And let's say the second in charge for that party is the vice president. And in the scenario when the actual head of the party explicitly dismissed himself from running for any office in the future. The thing is not if you trust it or not. It depends on your political taste. But basically, you are putting in prison the de facto most important person of one of the most prominent or the most, let's say, resourceful opposition parties for purchase of real estate for a medical university, which still belongs to them, which happened some 9 years ago.
We mentioned most of the details, but also I want to mention that Armen Ashotyan was indeed a thorn on the side of Nikol Pashinyan. First of all, as a MP, he was frequently participating in inter-parliamentary assemblies, in assemblies of political parties, and the Republican Party is part of the one of the largest union of political parties in Europe, and they have in fact condemned his arrest, both externally and internally, with his daily almost lives. Whenever Pashinyan said something, Ashotyan digested all of that in an hour, sort of live, Facebook live form. And, I think that was also part of the reason why he needed to be silenced.
And one more thing, Hovik, unlike a lot of other opposition leaders, he was actually very charismatic and popular.
They cannot even, I believe, during the trial, could not even identify who is the victim of this crime. The property is still there. It has appreciated in value tremendously. And so they initially arrested him and released him on bail. But then suddenly they put him back in jail because he violated his so-called, according to them, he violated his conditions. And those conditions, and it's not even clear if these recordings are accurate. But there was a recording where someone said, well, do you want to talk to Ashotyan's lawyers? And just based on that recording, they arrested him again. It's not proven whether this person actually followed that advice. It's not proven that Ashotyan was behind this advice. But just on that, he's now in jail. Meanwhile, we know that, for instance, Vahan Kerobyan was recently arrested and suspected of corruption, and then subsequently put on house arrest. But just last week, I believe, he was released because, again, there is no victim, there is no identifiable victim in the crime. So yet, Ashotyan has been in jail for more than a year now.
Yeah. There's the contrast between this type of things. I think is that we should draw that let's say which case is beneficiary for those who are in power, because when you are charging one of your ministers, of course, that's not something that you could simply dismiss the minister. But then, if you are when I was saying you, I mean the government, because of course this being done by the government. In the end, they have all the leverages. It doesn't matter if there's a prosecutor or what. In Armenia, all the leverages with the executive power. So you don't have this, let's say, political gain with that. Maybe some populistic gains, but I don't think it was the case with Chalabyan. But with Ashotyan's case, you clearly have the different purpose to that, and that's what we use when you are evaluating if someone is present politically motivated way or not. Even if there was a case for charges for criminal investigation, the overwhelming, let's say, bulk of other purposes of isolating him, clearly they overwhelm whatever happened with this, with the story of this, hotel or apartments which still belong to the owner. So in this way, in this situation, we have to look if the let's say political purpose overwhelms the legal one, if there is a legal one. And in Ashotyan's case, it's overwhelms completely, just pushes it off balance.
And for the last case of political persecution, we covered this case in the first installment of a Spotlight on Silence, but I think that given the PACE report, I think it's important to bring this up. Avetik Chalabyan, he is a prominent opposition politician, and he was a prominent opposition politician when this happened, and has been a scathing critic of Pashinyan. In 2022, he was charged with motivating students materially to participate in opposition rallies. This was not even something that happened. This was apparently discussions and recordings, and we don't even know the full context of the recordings. Ultimately, in December 2023, 6 months ago, a guilty verdict was issued against him, banning Chalabyan from organizing and participating in assemblies for 2.5 years. That's one of the most basic rights. I mean, I understand organizing, but why participation in assemblies? The case for him is currently under appeal. Your organization, the Helsinki Committee of Armenia and the Armenian Center for Political Rights, have issued a report on Chalabyan, which, as I said, was included in the PAC report. What can you tell us, Rafael, about the case? Are you aware of, for instance, where it's at in terms of the appeal process? Normally, these appeals run for almost like a decade, right? By the time it goes to the ECHR, and by that time, his 2.5 years punishment of not participating in rallies or organizing rallies will be a moot point anyway.
Yeah, well, as far as I know, so the verdict was appealed, and it's still not in force since as long as it's appealed. But get back to the case itself. So again, I think we covered already was the issue with this article itself. So it contradicts the guidelines. It contradicts the international standards. It was passed with quite this obscure manner because of the translational issues, and now we see the Council of Europe criticizing it and suggesting the government to resubmit that article for the review. And if it's, let's say, if it's decriminalized in some point of time, they were going to be acquitted automatically, and Chalabyan and all the others who are charged with this. Actually, if you look into his case, because there were many materials which have been published by the investigative committee, I think, and one of them was this recording of a conversation where he allegedly were offering money. It's in Armenian, it's in a bit in slangish sometimes, but anyone who would listen to that, the idea would get is not that he was offering money, but he was being extorted to offer money by the other person who was supposed to receive that, is supposed to mobilize students and asking for what you would give for this. So, and Chalabyan was saying, well, I mean, we are participating for our ideas. And this guy like very blatantly says, yeah, ideas are good, but everything has some worth some money. So basically extorting him to suggest to offer some remuneration for some actions.
Sorry, in English, this is called entrapment. And I know that police and law enforcement in the US have been criticized on this aspect. But are you aware of laws in Armenia against entrapment, especially when civilians are used? It's not even the police that are using this, but it appears that a civilian is acting under the direction. At least that's what you're insinuating, that they were acting under the direction of the police to sort of frame this guy and have him, appear to have committed a crime or something.
Yeah, I mean, this is also tactics used here in some cases, and I think there are some situations which, well, to me, there are, let's say, which are quite okay to do that. Let's say, if you are investigating some, let's say, drug use or drug dealers, and it's completely different if you are, let's say, going as as an undercover police officer to use this technique to reveal the drug dealer asking for drugs, if they have drugs, so they have them. Yeah, sure. I mean, it's already illegal. So yes. In some cases, I think it's a technique which is serving the right thing. But yeah, the parallel was quite nice because it really seemed that way. But again, we are not talking about drugs or some illegal or harmful activity. This is some regulation which contradicts the international commitments that Armenia has. Having this in mind, let's go fast forward to the moment when he was when the court verdict was published, and there are several aspects to that and several things to talk about. But one of the I think things that many people noticed, well, of course noticed, is the judge who delivered the verdict. So this judge, this particular person, Armen Ashotyan, ask anyone who ever worked as a, I don't know, starting from journalists to attorneys to prosecutors, everyone who ever had some idea of the political life in Armenia. This person is a let's say a legal meme himself. He was basically the same judge who condemned Pashinyan after 2008 protests. He was the one that been always, whenever he was involved in a case, so basically people were perceiving him as the government's so-called executioner. So if he's in charge with this case, there's absolutely politicized, and there is something that the government wants, and he's going to do that very well. Actually, there was the idea to put him in an anti-corruption court president's office, which they didn't because there was this huge outrage against that from all parts of society and many organizations. But then again, we have to keep in mind that it was the judge that delivered the sentence. And the sentence itself is the deprivation of the ban of organizing assemblies. What it reads actually is there's this type of sentence which is called, more or less literally would be deprivation of the use to engage in certain activity. It sounds like legal nonsense maybe, because it's not clear, but this punishment, this type of punishment has its roots again in this USSR, post-USSR area, which was meant for those people who were engaged in gambling or other activity which would, let's say, deprive their family from the means, or some harmful activity which was, mostly was used in the gambling area, let's say.
Was that not used against Dostoevsky?
So, or maybe someone misusing the hunter's rights and using the hunting rifle in an inappropriate way, they may be deprived of that. But using this punishment to deprive someone from a fundamental right, this was something unheard. And basically, some similar regulations I found only exist in Kazakhstan. From the jurisdictions that I tried to find, is completely different in its formulations, but basically there is a possibility for someone to be deprived of organizing assemblies or protests. But we are talking about Kazakhstan, which, let's say, doesn't have a vivid history of protection of the right to peacefully assemble. And then we have this sentence here. So this itself, this sentence itself, just disregarding the Article 136, the existence of this kind of sentence is itself very alarming.
Does the 2.5-year sentence actually make any sense? Does it come from anywhere, or is it a political one? Because if you look at when the 2.5 years ends, it's actually exactly June 2026, when there will be new elections. So essentially, to me, it seems like this government is saying they don't want Chalabian active until they are having their next elections.
It's very hard to understand it in any other way, of course.
Right. Why isn't it 3 years or 1 year or 1.5 years? Why 2.5 years exactly? All right, let's leave it there for today. Thank you, Rafael. That was a load of material for this conversation, and we'll come back with further topics, I guess.
Thank you, Rafael.
Yep. Thank you too.
And that's our Spotlight on Silence show today. This episode was recorded on June 28, 2024. We were talking with Rafael Ishkhanyan, who is a lawyer specializing in human rights, particularly freedom of assembly and expression. He coordinates the monitoring of peaceful assemblies at the Helsinki Committee of Armenia and is a member of the ODIHR panel of experts on freedom of assembly and association. In 2023, together with colleagues, he co-founded the Armenian Center for Political Rights, a watchdog organization focusing on detecting, responding to, and preventing political persecution and safeguarding political rights in Armenia. I am Hovik Manucharyan.
And I'm Asbed Bedrossian.
Please find us on social media, follow us everywhere where you get your Armenian news. The links are in our show notes, and please don't forget to donate, podcasts.grung.org/donate. Thanks for listening. We'll talk to you soon.